If the government wants more time, the max is 3 days. And if the defendant wants more time, the max is 5 days. Even when there is an immigration detainer, which is fairly common, or other type of detainer, we shouldn't be conceding detention. Some people aren't even being given counsel at that first hearing. And so there is an effort in those districts to fix that. Hello again. This is Lana Manitta with Rossen Law Firm, and I'm going to be talking to you today about pretrial detention in federal criminal cases. Before we get started, remember to like and comment on this video and subscribe to our channel. We post videos providing education on a wide variety of issues arising in criminal defense. So let's talk about pretrial detention in federal criminal cases. It is governed by statute, a statute called the Bail Reform Act. It's at 18 U.S. Code 3142. Now, the Bail Reform Act strongly favors release without bail and without even conditions on release. So why then are so many people being detained pretrial in federal cases? There are a number of reasons, but the one that I want to talk about today specifically is counsel's failure to advocate. The act says that a judge shall release the defendant at the initial appearance and should only even have a hearing on the issue of release and conditions under limited circumstances. And so from the very first appearance, the Rule 5 hearing it's known as, counsel really is supposed to be fighting for release if the government starts asking for detention. And if they're asking for a hearing, counsel needs to ask the court to hold the government to make their threshold showing that the criteria are met to actually have a hearing, and then be demanding that that hearing take place immediately, as per the statute. Now, if you need more time or more information, you can seek a continuance, but you should have the hearing as quickly as possible because defendants are detained during that continuance. And the act says if the government wants more time, the max is 3 days. And if the defendant wants more time, the max is 5 days. So then once you have your hearing, you need to be looking into sufficient conditions to ensure the appearance of your client at court and the safety of the community. And there are a number of factors that need to be considered by the court, and counsel needs to be prepared to address each and every one and argue why they inform release and not detention. In some cases, the law does presume that there aren't appropriate conditions that will suffice. And again, these are really limited by the Bail Reform Act, and that presumption is rebuttable. The burden shifts in those cases to the defendant to rebut the presumption for release by clear and convincing evidence. And although that's a difficult burden to meet, that does not mean that detention should be conceded. Even when there is an immigration detainer, which is fairly common, or other type of detainer, we shouldn't be conceding detention. Only if your client's detainer is going to cause them to be moved really far away or to another jail that they won't be able to get out of, should that stop you from arguing release. And even then, we should leave it open for reconsideration if circumstances should change. Now, if all else fails and we're at a point where we're arguing for conditions, the Act says that the conditions placed should be the least restrictive necessary to ensure the client's appearance in court and the safety of the community. Now, some districts use secured bonds and other districts don't. Some districts have electronic monitoring or GPS monitoring or home detention or curfew, and some generally don't allow these or don't like them. It's important to familiarize yourself as counsel with the usual conditions that are imposed by a particular jurisdiction or judge, but not to get bogged down in that and to be creative and suggest suitable, feasible conditions that may not be the norm, but that are the least restrictive and that are available. Now, this is just an introduction that I've given you a snapshot into federal pretrial detention. And the reason that I'm talking about it is it's become a little bit of a hot topic in federal criminal defense. At conferences that we attend on an annual basis or even more frequently, it's coming up every single time. And what's been discovered is that number one, there are districts in the country that aren't allowing for counsel advocacy at the initial appearance, even though it is constitutionally required. And the Bail Reform Act calls for release at that first hearing. Some people aren't even being given counsel at that first hearing. And so there is an effort in those districts to fix that. But then even in districts where there is counsel either appointed or hired as early as the initial appearance, statistics are showing that counsel is sort of letting the government get away with asking for a detention hearing when it's not appropriate, and even having a continuance longer than appropriate, and having clients be held in excess of the 3 days or excess of the 5 days, perhaps over a long weekend or even longer, while the government basically is preparing their case for detention in cases where it's not appropriate. And so when you're hiring an attorney for a federal case, it's really important to hire somebody with the knowledge and experience to defend effectively from day one, from the initial appearance forward. And that starts with making sure to get the client out, if it's possible, to get them out so that they can meet with their client and meet with their counsel, be with their family pre-trial, because it's a really important factor in preparing the defense for trial or addressing plea offers, and really being an effective advocate for the entirety of the case. So if there are other topics in the area of federal criminal defense that you'd like to hear me talk about, or other areas in criminal defense in the state courts of South Florida that you'd like to hear my colleagues talk about, please comment on this video, like the video, and subscribe to our channel. And if you or anyone you know is facing criminal charges in the state courts of South Florida or in federal court, please contact the Rossen Law Firm today. And thanks for watching.